All right. Well, I'd like to welcome everyone to today's webinar, Copyright Myth Busting, Why Your Assumptions About the Law Are Wrong and What to Do About It. This webinar is brought to you by Renewed, the open network for specialized subscription, membership, and event professionals. My name is Stephanie Williford, and I'll be your host for today's event. During the presentation, everyone should be on mute. If you're unable to hear or see the presentation, or you have any other technical issues, you can private message me through the chat in Zoom. If you have questions for today's speaker, you can submit them throughout the presentation and at the end during the live Q&A using the chat. After the presentation, you'll also have access to the recording at renewed.net/resources that will be available within about 1 week, and we'll send you an email once it's posted. We also encourage you to continue the discussion from today on Renewed's Guild group or on social media using the hashtag Renewed. Now, on to today's speaker. We have Tom Hagee will be our interviewer, and he's the founder of HB Litigation. We also have Rob Powley, the founder and lead at Powley and Gibson. In addition to today's presentation, Renewed has partnered with Powley and Gibson to offer a special member benefit. The firm will do a consult at no charge about your intellectual property problems or questions. So we'll include their website links so you can reach out directly if you have any specific questions related to your company. So I will let Tom and Rob take it away. Thanks, you guys.
Excellent.
Thank you, Stephanie.
Thanks, Stephanie. Yeah, so Rob is he is the real deal. I won't read his entire bio to you, but he is the real deal when it comes to intellectual property and in general, and copyright matters in particular. So he's been doing this for 30 years. He's got all the right credentials, all the right licenses and memberships, and also got his law degree from Washington and Lee School of Law. I was also impressed, Rob, with your people the folks you've represented in the past. You know, big retailers, big food and beverage, you did some in the fashion industry, which that's my life. And then, but you also listed a world famous sculptor and worked on one of the most successful Broadway musicals in history. So we don't have to go into that, but they caught my eye.
Okay.
Not every lawyer has that kind of color in their background, so I want to call it out. So, so as Stephanie said, this is designed to tell you how much you think about copyright and what you think you know, and how much of that is wrong. And it's mostly inspired by my own beliefs. And at least I was aware enough to know that that my understanding of fair use and copyright is certainly out of date. So unlike Rob, I will not offer you free advice as a member benefit. So Robert, if you're ready to go, we can just jump into the first question.
Yeah, I'm all set. Thank you for the introduction.
Yeah. Well, it's great to be working with you. So the first myth that we wanted to get to, so it's on copyright and fair use. So how much of an article can you use when writing your own articles? I've operated under the assumption, and a lot of people have, is this magical 10% figure. I can use 10% of your article in 10% of my article. Isn't that true?
Yeah, and that's an excellent question. You know, we've seen over the time a lot of people, as you've indicated, that have sort of that understanding, and sometimes their percentages vary from 10 to 20 to 30. You know, I've heard all sorts of things, not only from management, but journalists as well. And actually, there is no black letter law onto what percentage you can take, and that's really sort of a misunderstanding that can sometimes lead to unfortunate consequences. You know, and when I first of all, I was going to go a little bit into how fair use is implemented, but I'll touch to that. But when you look at the factors, actually the courts almost universally in the U.S. Look at several factors to decide whether or not the content you're taking from a third party is going to be an exception or a defense under the fair use theories of law. And the first thing is really focuses on the nature of what you're doing with the work. People have called it transformative or other things. Do you build on what was done in the journalism world? That could be like, do you comment, criticize, even parody, sometimes humor, certainly has received protection. But so the first step is, what are you doing with what you're taking? And then they look at another factor, which focuses on the nature of the original work. And the best sort of bracketing to look at that, and there's a continuum on both of the, through these two extremes, but factual works generally are afforded very little protection under copyright laws. Facts actually cannot be copyrighted. So if a work is primarily factual or a compilation of factual information and things like that, that may be entitled, when you're looking at all the fair use factors, to a lower level of protection and may favor fair use defense. If the work is more analytical, new thoughts, critiques, comments, even some type of opinions on how to handle matters or how the law is changing. I'm sorry, that's back to the transformative, but if your work is more along the lines where it's creative and such, you're going to be more likely to avoid fair use defense, or if you're actually using the information, your fair use defense will be more difficult to sustain. And then the next factor they look at is the amount of the original work and the substantiality of what you've taken. So this is where I think the belief of the percentage comes in, but there's really these two critical factors. It's not just the percentage, it's also really the substantiality of what was taken. So what I mean by that is, if it's some introductory language that's not very creative, that can be taken more easily than when it's in the heart of your analysis of a particular topic. So there's the amount and how important the amount that they're taking is to the article that's being used by a third party. It impacts the fair use defense. And then the last factor that they'll look at is the potential impact on the marketplace of what you're taking is doing. The obvious example when it exceeds what's permissible is when people are doing some form of subscription replacement. Like they bring in a publication into a company per se, and then someone creates a digest of all the articles and then circulates that instead of buying more subscriptions. That probably wouldn't be subject to a fair use. And then, mixed in there too with the character of the original use, when I talked about transformative, there's, as we all heard, more protection for educational uses, less protection for commercial uses. So the test of fair use is actually pretty complex. All the circuit courts in the US have some twist on those themes. And a little bit of the flavor. So the next point of the analysis is, where would you be inserting the fair use defense? Where does your company live? And again, I'd like to point out to people too, the fair use defense is a defense, and it's actually qualified as what we call an affirmative defense. So it's not, or doesn't immediately get you out of a threat from a third party. The way the law would work is the third party establishes that there's infringement, but you can defend or excuse that infringement through an affirmative defense. So what I'm really trying to say is if you're stuck in litigation because you've taken too much content from someone, the real problem becomes you may be stuck paying a lot of money to defend that fair use defense. So, and that practically, even if it's legitimate, could really force you to do things that that you wouldn't want to do as far as using third-party content. Legitimately, you could legitimately be within those parameters, but get an aggressive plaintiff. So it's not black and white. No. There's these series of multiple factors.
Yeah, it's so the answer is it depends, and then there's a long explanation. I guess what would a rule of thumb? What might a rule of thumb be? I mean, for example, if I'm going to use something, it's got to be something that only that publisher had, and I'm going to quote them, and I'm use as little as possible.
Yeah,
so,
yeah. That would be that you're right. You're exactly right, Tom. I'd be using it to comment on what they said, or have some relevance to what you're doing. I would take a very small amount. I'd clearly identify it as their content. I'd provide them attribution, and if you're in those parameters, I think you're going to have a very strong fair use defense. Okay. Attribution is one of the real keys, and a small amount of taking. Really, the amount that you need to make your point, and hopefully it's not 30%, 50% of the article.
Right. Yeah. And I do know some things that are public information. I believe from journalism school, the rule was you would never say the sun came up today according to the New York Times. So if it's public information, it's generally fair game. Well, let's go to the next one on infringement tracking. So once we send a subscriber an email with our content in it, there is my assumption is there's no way to know how many people they're sharing that with. Is that right?
Yeah, I think there's a lot about that's actually accurate, but then there's also some other things that can really help inform you what your people or your subscribers are doing. Because generally right now, if the only pure way you can really know what's happening with the publication you forward to someone is some form of tracking. And, if you're ever stuck in a litigation, every defendant expects that you should have tracked, so you could have discovered this earlier. But that's very impractical because most publishers have a broad range of subscribers that have different security needs on their personal firewalls and such. And implementing tracking can sometimes make the third party's system vulnerable to attack. Also, too, it makes the relationship with the publisher and the subscriber very cumbersome. Everyone struggles to get sales. And now when you say, well, we have to put some tracking system on your computer, your sale may walk right out the door. But as far as from an enforcement perspective, it's interesting. We've seen with a lot of these email delivery systems that people are using that involve some form of pixel indication system. We're also seeing now that, Apple's introducing some limitations on their new iOS to that. But generally what you could see, say, for instance, if you're using SendGrid, which is a pretty common email delivery system, early on, they used to just say that they received your email to process it, that they delivered it, and then someone else opened the email. And that's really just the email, the cover email, because there's an embedded pixel that's giving feedback to the SendGrid servers. Well, they sort of stepped up their game around 2018, SendGrid did. And now what they give you is a lot more data about who's opening the publication. And this is getting more and more commonplace with all these subscription fulfillment services. And all of a sudden, they give you now a list of every IP address used in association with that email of the subscriber. And you can look at that, and it doesn't tell you exactly what's going on with the publication that's attached to the delivery email. But it's interesting. You start seeing your subscriber all of a sudden is geolocating to, Houston, York, Canada, California. And you're like, well, why would you forward that cover email if you weren't doing it to forward the publication? Often it's an auto forward rule behind someone's intranet. And it gives you more than enough information if you want to begin some type of enforcement measure, even if it's not a litigation, just to reach out and say, we suspect you're infringing. So there's very helpful, reliable information that can be obtained that's going to give you with 99% certainty that there's infringement going on if you see that type of data with your email delivery system. And it's certainly, we've litigated many cases where that's been more than a sufficient basis if you had to begin the lawsuit to say, someone's infringing your publication.
Interesting. Okay. Real good. And so when it comes to copyright enforcement, so if we're going to pursue somebody for infringing copyright, I feel like that's only going to alienate customers and not get me much in return. That's my assumption. Is that accurate?
Yeah, I think that's a common worry once again. I mean, I guess that's why we're myth busting here. Mm-hmm. And I think, absolutely, if someone reaches out to us with that type of inquiry or that concern, because we've seen it pretty widely, it does draw on, I think, which is a very rational business decision. How do you approach this? What can you do? But, there's many steps that you can take absent just doing full on litigation. And I think, lots of times when you find a customer that's infringing, they right away go on the affirmative attack if you start being too aggressive, saying you're trying to take advantage of me and things like that. So we've told people, one of the things when you're trying to evaluate this business decision is look at your own sort of sales history if you can. Look, how often has your salespeople, if you have them, reached out and say, hey, we're just checking. Do you like our publication? Do you need more copies? If you have this history of people saying, no, one's already enough, you're going to be on what we always call this moral high ground in the litigation to sort of explain your basis for looking to do something, for looking to enforce. And I really tell lot of our clients that it's, your publications and the copyrights in them are a serious asset of your business. It's really one of the only asset other than branding and things like that, maybe some know-how, customer lists and stuff like that. But it is an asset just like money in your bank. And if people are taking it without charging, you're certainly within what the Copyright Act is designed to do to speak to them about that. And then we found too that, sometimes you do have to go to where you file a lawsuit to get someone to even respond to you, but you don't have to really continue that, because after you file something, you have a period of time before you have to serve it. And once that happens, usually the door with the subscriber opens up for the salespeople to go in or the business people to go in and talk about a practical resolution. And we found, rather than saying, I'm going to get maximum dollar per infringement, you could say to a subscriber, like, listen, for what you've done in the past, we're going to sign you up for a more accurate level of subscription, maybe more of our publications, make them prepay a period of, say, 3 years to the publication. And what it does is, you get a lot more revenue. It gives the subscriber an asset, because rather than just saying damages, they're getting maybe several of your publications for a period of time. And it actually, we've seen that subscribers sort of get educated about your publications. And so if the resolution is paying up front for, say, a multi-year license, at the end of that period, people forget about the infringement and the lawsuit. They're more, people become dependent on getting your publication, and your renewals become greater and easier. So there's ways to approach it without alienating your customers. And it's very much a business decision as much as anything, but it's certainly possible to do it. And, it's very legitimate to do it. I mean, it's an asset of a publisher's company.
Yeah, I would say just out of the gate, just a quick sound check, Rob, I think you might have something rustling near your microphone.
It might be my jacket.
Okay.
Buttons on my jacket. Sorry.
No, that's all right. We'll deduct it from your fee. The thing is that what I'm wondering about, litigation is like the last thing anybody wants to do. So some of the things you're talking about are ways to resolve infringement without going to court.
Yeah.
Right?
And I gotta say, every time that, not every time, but nearly always, the copyright provides much differently than, say, trademark infringement and such, for recovery of attorney's fees. So every time we've had to do that and focus on damages, people would be very surprised about the results and how much revenue is brought in for our clients. Mm-hmm. And then, from a business analysis, if this big company has only had one subscription, you're only getting one thing, and then now all of a sudden you get revenue and they have to pay your fees. So it's not something people want to do. Litigation is hard on businesses. It's hard on your subscribers, but, and then every resolution is always, they want a confidential settlement agreement. And believe it or not, your subscribers don't want to run out and say, yeah, I got caught infringing. So it doesn't generally become public knowledge. So there's a lot of opportunities to resolve that don't necessarily mean alienating my subscriber.
I gotcha. What about the copyright registration process? It's been a while since I've done it. Can you register? I assume you can register your company's work annually, and then you're just fully protected as soon as you apply. Is that right? Yeah, no, and unfortunately, the copyright registration process is a little different than that. And actually, it really evolved meaningfully in 2019. The Supreme Court did a decision. The lead plaintiff was Fourth Estate. And in that decision, to back up prior to that, it used to be that you could start a lawsuit if you just filed your application. You filed your application with the Copyright Office, and you had the application pending with deposit materials and paid your fee. Most jurisdictions would let you continue the suit. The Supreme Court finally visited that issue after decades of courts going on the application being sufficient to start a lawsuit. And they said, no, you need actually to have a registration. So what that really means, if you do find out an infringer exists and you haven't registered, you have to now go out and get your registration.
And registration fees are relatively nominal. I mean, we encourage people, we sort of oversee some of their filings, but it becomes something that's very automatic and they can handle in-house once they get a few under their belt. And a fee for an individual work is around $35. And then there's group registration for where you can register, for instance, on a daily publication, an entire month at one time. For bi-monthly, weekly publications, you can do 3 months at a time. And that fee is $95. Now, if you've waited and you have an infringement problem, unfortunately, now you have to go to the copyright office, and unless you want to wait, they're right now backlog 11 months. But if you and you may not want to wait that long because you could have a statute of limitations issue, and the Copyright Office, if you want to expedite the registration, really jumps it up to around $800. And you have many works that can add a big expense. But the other thing too, I think, that's more of the context of I have an infringement. But the other side of things too is when you go to the effort of registering your copyright, a whole world of remedies open up for you that you don't have if you register after infringement occurs, outside the 3 months of publication, and generally even later than that. And what happens is if you get your registration after the infringement and it's beyond 3 months from the publication date, then you really only you don't get attorney's fees if you try to enforce your work. And you really started getting actual damages only, which is how much they would have paid in most subscription-based models for a subscription if they had gotten it properly. There's no, but when you register within 3 months of the work being published, then there's rules whether you're doing monthly groups or otherwise. Now your work gets presumptions of validity, and the statute sets damages, minimum damages if you have copyright notice, at $750 per copyrighted work infringed, up to $30,000. And if the court determines, or whoever's deciding the issue, a jury, that the infringement was willful, that range goes from $750 to $150,000 per work. And actually, Congress is looking right now to increase those ranges. So, if you register within this 3 month period, because usually infringement occurs the date the publication is sent out, because people want their information currently. So you have this 3 month grace period, and if you register then, you have the wonderful benefit of getting, you don't have to prove actual damages. You can elect to do statutory damages. They know they have to pay your fees. So all those things give you a better leverage when you're going back to our last topic. You want to approach someone and say, what are you doing? We want to work out appropriate license. They really don't have to ignore you as much, because now they know they have to pay your fees. You have all these damages available to you, and that's all based on the registration of your work in a timely manner. Can you wait a year and do them? You can't do them as an annual group, but you can do them, once a year. But you don't save any money. The pricing is the same, and you lose a lot of statutory rights. And that's usually the whole key in settling a case early and getting enforcement and a remedy quickly rather than pursuing litigation.
It sounds very manual. And it's been a while since I've done this, and since I get to ask the questions. I mean, is there an automated way to handle your copyright registration?
It's not really an automated way per se, but the Copyright Office is online now. Yeah. So it's very easy to do it. You used to mail things and such, but now you can scan in copies of things and do it completely electronically, which really facilitates that. Good.
I see some good questions coming in, so we'll have plenty to discuss toward the end. Let's see. Let me just check. The next question I wanted to get to was licensing. So once you engage in a license, it's forever, right? Besides, aren't all licensing agreements, don't they say about the same thing now?
Yeah, I would probably disagree. These are all set up to disagree with to stimulate questions. So I'm not
you
trying
can just
to be.
say, Tom, you're a complete moron. So, let me
So,
correct you.
to Tom's defense, I should point that out. But no, it's not really true. Licensing is interesting, I'd say, from two perspectives. It's very hard. We work with people to have a clear license. And when people try to make their license more clear, and if they're not really schooled in it, they haven't litigated it many times, they usually make their agreement more ambiguous, which, creates problems with users and enforcement. Legitimately, the only thing you need to do, but you don't even actually have to do that, but to get full benefit of the Copyright Act, you have to put copyright notice on works, the C in the circle, the word copyright, but those can be switched out, the name of the company that owns the work and the year it was published. But license agreements are helpful. And it's good because a lot of defendants say, well, you never told me what I should do. And I don't know copyright law, which isn't a viable excuse. Again, this is that moral argument if you're trying enforcement, because there's no mens rea requirement with copyright infringement. There's you did it and you're liable. The more willful you are, the more problematic it is, and the more there's a need for deterrence and punitive measures under the act, but you did it. The interesting thing I think people aren't aware of, though, with licensing is some people, have a model that's a subscription model, and they may have a license in their terms and conditions where they say, hey, these are what you can use and such. But if you don't specify in your license agreement, and I think this is the main difference, that the people have the access to that work for like the period of the subscription, and then at the end, their right to the work ends, your subscription really becomes much like a sale of a book. And what I mean by that is when you give people the publication and they're just buying an annual subscription and there's no terms governing, what they can do with them and how long they can use the book, it becomes just like, a book that someone could buy at Barnes and Noble. And there's what we call, you may have heard, the first sale doctrine. So after that person gets that work, they can keep it forever. They can, as long as they don't copy it, they can sell it to someone. They can actually internally, on their email, not on a server, but their email where they receive the publication becomes a historical archive. And some people have said, well, gee whiz, I don't want them to have an archive of my publications. When their subscription's over, that's it. I want a source of our business to go to our website and access the archives there. Well, if you want that and you want someone to, not have a right to use your publication or read it after the subscription term ends, you really need to have a license that says that the use of the publication is only for the duration of the subscription agreement. Absent that, once they get the publication, it's forever. You have you sort of lost your right. I mean, they can't copy it, display it still. That's never permitted. But you can't control their the subscriber maintaining that work. I mean, they could take that work and take, a body of printed copies and donate it to a library. You can't say anything if you don't have licensed language. And if, the difficult thing is if you don't have licensed language and you try to assert a right to stop their use after the subscription term ends, you actually are committing what's called copyright misuse, where you're starting to assert a right in the publication, in the copyright in the publication that's not provided for by the Copyright Act. And that actually can expose you to liability. So there's a big difference when you look at license agreements. They're not all the same. Some of the things, your goals that relates to your business really need to be factored in. And, you really have to be careful and make sure they're clear. And then the last thing you need to do is think about where your subscribers live, because license terms here and as they're interpreted differ from how they're interpreted, for instance, in Germany. So, sometimes you want to put in your agreement what law will govern. That's important. There's a lot of things that are important in a license, but it's they're definitely not all the same, and it doesn't have to be forever.
Okay. I swear I've seen licenses where they actually make reference to protections throughout the known universe. Am I making that up?
Yeah, no. That's just an aside. There was a time when music came out and it was like on an album, and the agreement covered the album. And then they said, well, now it's going to be on a CD. Right. And people said, well, you didn't license the rights to the CD. And the music company said, well, no, I got the album rights. The CD is really the same thing. And the court said, no, that's different media. Sorry, you didn't think about it. You need to approach the artist and get a new agreement in place. And so to avoid that, common language and all license is use. And now in all media known and hereafter devised throughout the universe was the catchphrase that the court said you can employ to make sure that when you buy the right to something, you have that right, and for a publisher, it comes into translations, different, right. Abridged, amended copies, all those type of things is how it feeds into the publishing industry. But right. You're right. Everyone gets a kick out of that phrase when they read it, but there's a real basis in law for it.
Okay. There usually is. What about freelancers? So I'm using freelancers, and once I contract them to write an article, I own that content outright. Isn't that right? Don't they release the rights to all of their work? And,
that's sort of a yes and no. I mean, people look at freelancers and stringers and other things, and they always say to me, they're work for hires. I own whatever they contribute for me. And that's not really the case. The Copyright Act is very, very clear that a work for, and the difference, just, to back up, when someone does something as a work for hire, it means your employees are writing for the company. The author for the resulting copyright registration is the company, even though the employees worked it. I mean, you can still put bylines, who wrote it and everything. That's different. But the owner of the copyright is the company. The company is considered the author. When you have stringer agreements, you can't really say that. And the Copyright Act, actually, when you're outside the employee-employer relationship, and even in that circumstance, your employees to own their content, they have, you can't hire someone to write articles, but they're really good at graphic design, and it's not in their job description, and then they're doing illustrations. There'd be a great argument that that's not a work for hire because it's beyond their job description and they're not getting paid to do that. But if they're being paid, they're a work for hire and you own it. To a freelancer situation, people want to blanketly say it's a work for hire, but you're not within any longer the sphere of employer-employee relationship. You're just, you're hiring somebody. And some countries, particularly if you have journalists around the world working at different bureaus for putting and gathering content, prohibit work for hire. It's just a novel thing. They don't even understand it. The law doesn't recognize it. So you do have to honor the law of those jurisdictions. You may say that U.S. law governs, and that sometimes provides for it. But to own their content, the best way to do it in your stringer agreement is to have an obligation to assign any authorship that they have to the work that they're creating for you. And we still encourage people to say, that in the stringer agreement or the freelancer agreement that you call to work for hire. Alternatively, if it's not a work for hire, that you have an obligation to assign it, because the law for what a work for hire is evolving. It's always different. And I wouldn't be surprised down the road of it, because people aren't, people are working more and more remotely. There may be some changes in that. But you're not going to automatically own something. You're going to have to put with your freelancers a right or an obligation to assign their title to you. And the other important factor to even remotely try to have it automatically as a work for hire, or even to facilitate the ownership, it's critical. And the courts have really talked about having that agreement in place before they begin the work. So, and that's really designed in the law to protect artists, that they know when they're preparing this for you, that they're not going to own the copyright in it. And it's not where they give you the article and now they want to get paid. And you say, well, I want you to sign the copyright. And they're like, well, no, I didn't foresee that. And you're like, well, maybe I'm not going to pay you. They don't want that relationship, that potential exploitation to develop. So you can own the content of your freelancers. You should, because when you file your copyright for the resulting work, if you don't have ownership, you actually have to disclaim their contribution because you're not the author of that contribution. So this issue not only ties back to proper agreements, but it ties back to how you're going to, if you try to register your copyrights. So there's a lot of, I'm trying to dance the line. I don't want to get too in detail and bore everyone to death, but there's a lot to it. So
yeah, it sounds like it. And certainly, I guess there are different kinds of, not freelancers, but I guess when you get into guest articles, we get that sometimes where we publish something for lawyers, and routinely though we say they retain the copyright. We want to publish it, and then they can do whatever they want, especially when you're dealing with lawyers, because they're just going to beat you up anyway. So, but anyway, that's just sort of how we work in the legal area.
Well, that's practical times.
Yeah. So web content. So once assembly is not a word. Once someone publishes on the internet, I'm free to post all of their content with hyperlinks back to the original pieces, aren't I? I mean, if you put it out there, it's out there and it's public, it's in public domain, isn't it? Can't I just use it and link back to them?
Yeah, no, the answer to that is no, but boy, is it a complex area that's evolving almost every few months as far as decisions are coming down. Frankly, once they publish it, there's the same criteria you would look at, I would say, in a fair use situation. How much are you taking from what they're publishing? Is it limited? Do you give them attribution? Is it for criticism and comment? Or is it, replacing their marketplace to some degree? Is it commercial or is it educational? Are you doing it for university and studies? Or are you doing it for your business model because you're a publisher? So I would say there isn't a blanket rule that you can take the content and publishing something, whether it's on the internet or putting it in a bookstore. Publishing is defined. It's another legal term, actually. And publication is making many copies available to the public without a limitation of what the use is. So if you even exhibit an artwork and anyone can photograph it and put it in the New York Times, sometimes that is publishing actually, and sometimes it's not. But once it's on the internet, even if they don't put copyright notice, if they don't have copyright notice on their web content, certainly their ability, if they ever try to get a registration or they do register their work, that you're subject to claims of innocent infringement, or you have the defense of innocent infringement, and it lowers the damages to $200. But it still has the full range if it's willful. So you just per se can't take that content and just hyperlink to it. You're going to have the same analysis if you do for fair use.
Yeah. Well, I'd like a simple answer. I just want the 10% to be true.
So do I. I don't know. I have a lot more time on my hands.
No, you wouldn't. You thrive on the ambiguity.
It does help my business.
Yes, it does. Let's see. So tweets. I guess this is similar. I can embed a tweet right into my content, right? That's fair use.
Well, is it interesting? Actually, there's a split developing between the circuits right now on that. There's a case that involved Google that came out some time ago from the Ninth Circuit that said when you embed a tweet, you really weren't bringing the content. You were actually putting a window on your web interface or whatever you're doing to that original party's content. So you're not really copying it. You're actually just creating a conduit through your website to the embedded content that they would see through your website from the actual author still. You still be displaying it within your tweet from this third party. And so a lot of courts were handling it that way. But just recently, and very recently, the Second Circuit, or the case in New York, had a similar situation, and it was an embedded tweet, and everyone expected, like the legal community expected everyone to say, well, that's just a window to their other content, and it's going to follow the Perfect 10 authority that comes out of California. The Second Circuit and the Ninth Circuit don't really follow each other, but they look at each other a lot and they sort of respect each other. The Ninth Circuit's California. But the defendant moved for summary judgment saying, hey, this is just a look through. And everyone expected it to just be dismissed as fair use. But actually the Second Circuit said, well, now this was only early on in the litigation. I would say for summary judgment and board of what that means, but it's early on in the litigation. And they said, no, we can't dismiss your claims, because as much as there's very legitimate fair use arguments we're worried about and other things, one of the exclusive rights of a copyright is display. And when you do that embedded content, even though it's a window to their website, you're actually displaying their content on our website. So now all of a sudden, everyone thought this window exception to embedded content would really take the lead through a lot of the court's determination of that similar issue. All of a sudden, the Second Circuit just threw in this sort of right-hand turn to it and said, well, wait a minute, that's not really going to be automatically allowed. We really need to evaluate it. They still reference that there could be fair use. They referenced to Tom, what your point is there some type of implied suggestion based on the nature of tweets that when you put it out there, you expect everyone to retweet another tweet? Because some defenses, not only fair use, there's a defense called an implied license, an express license. Express is usually something written saying you could do it, but sometimes where the tweet is going on, there's language telling people if you use our service and you tweet to it, you're giving us the right and other participants, with our service to retweet it. So you're sort of giving an express agreement to do that. Sometimes there's an implied license, as you said, it's in the public, so the public can use it. But it's one of these things, not just, well, lawyers are the byproduct of it, but the courts now all of a sudden introduced this split. And now what we all thought was really pretty safe and generally permissible, there may be some risk associated with it.
Gotcha. So increasingly, AI is artificial intelligence is creeping into everything. I have to always say the full thing because when I type it, it looks like I'm saying owl. But anyway, AI is creeping into everything, and people are using bots to create content. So if I'm using a bot, especially if the content's not copyrightable, are my bot generated creations copyrightable? So what are the ramifications in copyright law by having robotic clipping of content out there on the web?
Yeah, well, it's an excellent question, and it's also evolving. Right now, if it's purely created by AI, artificial intelligence, or some machine-driven mechanism that's scouring the internet, web crawler, whatever, pulling content. If it's solely created by the computer, there's no copyright in that, and you can't obtain a copyright. You still may have problems if you're pulling content from another party, even though your machine's doing it. You may actually be committing infringement because your machine's pulling content, and you have to know that it's pulling content that really is in the public domain, and it may take some time for them to know that. But the Copyright Act says that authorship only vests in living people. So unless there's an amendment by Congress, right now there's a complete prohibition to getting a copyright. And people really haven't explored what that means. So if you took all public domain stuff and had your bot pull it together and created what might be ordinarily called a compilation, which is traditionally protectable, your selection of material and the pulling of it together can have some authorship, not in the content, but the compilation. But if you did that right now in the US with just a bot, you wouldn't have a copyright. And because of the Fourth Estate decision, you could never stop anyone from using your content because it's created by the machine. Now, the sort of split, the sort of twist of that is the bot's pulling things to facilitate your writing of stories. Like, the bot gathered this, then I went through and I pulled, it pulled 20 different sources, and I took 9 out of the 20, and then I commented on that. Now you're using a thing to help you, and you're still making the choice of what's going in, and you're adding some content too. So there's definitely hybrid methods where you're using AI, but you're still putting some creative expression into what's happening, and that you'd still have a very strong argument that you would own that. But right now, the way the U.S. statute is written, and that's changing. Not in the U.S., but there's decisions now coming down in different jurisdictions, particularly China. Just had a decision recently that a company, Tencent AI, they have a bot called Dreamwriter, and it was writing public stories completely on its own. And the court in China said that the owner of the bot owns the content and it is copyrightable. So, it's going to depend where your body is, I guess.
Yeah, yeah. Well, I mean, you mentioned it, international, because you can get tagged by, folks in other countries. I mean, is it law if I borrow something from a French publisher, that's unlikely. If I borrow something from an English UK publisher, what law is applying? Am I going to be sued under UK law, US law, both?
Well, there's a convention. That's a great question. There's a convention that's supposed to keep everyone basically within the same playing field. It's called the Berne Convention. It was signed in 1989. And what that means basically that, a UK author, if they have the copyright under UK law, they can actually come here and enforce their copyrights in the US against you. Even absent of having a U.S. registration. Now, the problem is, again, they don't have the U.S. registration, so they don't have the benefits of the U.S. statutes. There's no statutory damages. There's no other things. But they can come here to enforce their copyright against you within the U.S. And generally, if you're looking outside the U.S., do you have worries about being brought in other jurisdictions? It's so much as a case-by-case basis. But usually jurisdiction is governed by some fair use, not bad language, fair consideration of jurisdiction, that you have some presence there, you're doing some activity. And that's becoming more broad as we sit here today, because, the courts have generally said web activity alone in the U.S. is not enough to bring jurisdiction. It's, where you live, where your employees are, where you have buildings. But there's starting to be, there's recently a case again in the Ninth Circuit. There's something going on in South America, was having known impact in the U.S. And the court actually allowed the court here, the lower court, to have jurisdiction. So there's a lot of jurisdictional issues, but because of the Berne Convention, which almost every country in the U.S. has signed, it's like 99%. Any third party that has copyright could come here to enforce that copyright against you. Something like China, there's an AI created content, though, there would still be a question of whether or not viable question, whether they're going to, interpret that suit under Chinese law or US law.
Gotcha. Okay. So, Stephanie, I think we're about at the point, unless, Rob, you have anything you want to say before we go to questions. I mean, I had just a general one. You've been doing this for 30 years. Have you seen more copyright infringement questions coming to you or cases coming to you? I'm assuming there's more because it's a lot easier to steal.
You're exactly right. I mean, it's becoming more and more of a, I hate to use the word pandemic, but it's more and more of a problem for publishers because, sure. Earlier on, you used to have to go to the photocopier and make a copy of what you did and hand it out and things. But now, it goes to an assistant, because they're handling the workload for the busy boss. And they set up an auto forward rule because at the time, the boss says, gee whiz, it'd be great if my team could all read this. And, and they have the option of getting it generally and printing it and putting it in the library, which wouldn't be problematic. But, everyone's located geographically now, even more so in different areas. So, and the technology, and then you're also facing, intranets that are highly guarded and very protected. Mm-hmm. In the last few years, we've gone against, force for a publisher against every large bank and other international outcomes you can imagine. And, you can't get behind those firewalls to find out what's really happening.
Right. Gotcha.
So it's a big problem. It's getting worse. It's probably going to still continue. And I think it's even harder for people when they get the content from your website as much as, because once, they get to your website with a password and things, and they download the publication, say they want to print it out and bring it home on the train. Well, that's almost impossible to monitor that post.
Okay. Gotcha. Well, thank you for that.
Sure.
So Stephanie, do you want to go through some of the questions?
Yeah, I'm happy to do that. We've got about 10 minutes left, so maybe we can try to rapid fire these.
Sure.
I'll start with one I think is a little bit easier, hopefully. Maybe there's no easy questions in copyright, but for purely digital products that may not have issues, so maybe content that's pages that are regularly update, how do you register copyright for those?
Yeah, well, you would register, the first work that was there. And if there's, at moments that you think as a business decision are viable, you would do supplemental filings, and the first work would cover the original content, and generally the latter filings would cover only the new content. And you could do it anytime there's a substantive change for the $35 fee, and then second one would cover only the new content, or you could just do it sort of annually, and but you'd have that lapse. The new content wouldn't really be protected. But if the digital changes are de minimis over time, and you had the original layer copyrighted, I think that registration alone is going to give you a lot of protection. And I would always make sure you have proper copyright notice on your digital content.
Great, thanks. I'll mention too, I'll just reiterate what we said at the beginning, that Rob is happy to do a consult with anyone offline with specific challenges or questions they have, or if you have one a little bit more deeper dive into it, feel free to follow up with him directly. Also, as I'm going through these questions, if anything needs clarifying or you want to elaborate on it, if you're the person that posted the question, feel free to unmute yourself and just add on to that. Since we were able to do that on this call. So I wanted to mention those two things. So another question regarding the length of agreements, does it work against you if it's too long or too short? How much does the amount of language impact the agreements?
Yeah, well, generally, sometimes people try to assign rights in perpetuity, and that's generally considered too ambiguous. It becomes hard to enforce because it's hard to envision what that really means. But, the term is really elective, what you think is reasonable. And I think, I've often recommended to people, if they wanted to have the best of sort of both worlds, is to have it maybe on a shortened term with automatic renewal. And then, you could have, after, say you have 1 year with automatic renewal for subsequent annual periods up to 5 years, you get the best of both worlds. You can write in a termination right at the end of one period if you feel that your subscriber is problematic. And you do have, if you're going to charge money in the annual periods, you have to remember to give people notice, because you can't do that even though they sign up for automatic renewal without giving them a heads up, as you probably see in many things you personally license. But the term per se isn't too important, but things evolve so quickly, not only from the legal sense, but also businesses evolve. So, you can get stuck with something you have a really long term that you may not be happy with.
The question was also around just the amount of language in the agreement. So I know, like for us with our authors, we have a one-page agreement where we try to cover just the most important thing, which is assigning the copyright to us. So is that good that it's 1 page? Should we try to be covering every single question or issue that could arise? Is better, or is short or long better for a work for hire or copyright type agreement?
Yeah, I wouldn't say short or long is the correct sort of, I wouldn't look at it with short or long. I would look at it as making sure you're securing the rights you want and your agreement is clear. So if you need to be clear and it's 2 pages, no big deal. A lot of times when I do works for, artists, like one particular sculptor firm, say the works are very expensive. And, when they buy the sculpture, they have no right to publicly display it. They really, it's like buying it for your home. The public display right still stays with the author. So, those agreements, are 10 plus pages always, because there's maintenance, there's other things. So the length is really, should be a reflection of what your goals are and clarity. And if you can do that and with less language, that's great. So clarity is really the concern, and you want to make sure you're not ambiguous. I know it sounds like the opposite of clarity, but you want to make sure you're not ambiguous with like maybe creating implied licenses where you start making exceptions to, what you use it for. Like, an example you see sometimes is like, you can't reproduce this, you can't make archival copies, you can't do anything, but from time to time you can take out individual articles and circulate them around your company. And a business may like that because it's self-promotion within the company. But then you always see a defendant says, well, it says time to time. And so how do you qualify that? Do you say as long as it's not acting as subscription replacement, other things? But when you start creating exceptions to be helpful, which people should try to do, sometimes you create problems. And but I think it's really goal driven. And if it can be short and clear, I think that's nothing wrong with that.
Yeah, that makes a lot of sense. And I see Ed posted in the chat the copy of their independent contractor agreement. So encourage people to download that. We also have some resources at renewed.net/resources, a couple sample agreements and things like that. And I'm happy to share ours as well. So feel free to reach out via email or Guild to get samples of those. Another question, I think a little bit trickier, around fair use. If you take a small amount of content, but it replaces the need to read the original, is that tend to be more problematic?
Yes. You're going to have the amount of substantiality is one factor. So that factor is going to favor fair use because you're taking a limited amount. But if it's replacing, that's the fourth factor, fair use. If it voids the original use and you're taking away the marketplace from the original author, that would tend against fair use. And again, it's just, there's no black line, path you can pursue here. And it's wise to know of, hey, it's really critical content. And now people don't need to read the original author's work. You're probably treading more close to difficult grounds.
Got it. Thanks. And we have a member who's working on an anthology and asking if the book can be copyrighted if the publisher only has licenses to the content. So it sounds like they're licensing content within the book and wanting to copyright the collection, I believe. I might want some clarification on that.
Yeah, well, it's a very easy one, actually. Yes, it can. There's authorship in your compilation. So you may be licensing content, but the authorship resides in picking what content you want to put in there. And that becomes an effective copyright because often in those circumstances, the copying is the whole book down the road per se, right? So they would be taking your authorship. If they just take articles that you licensed, then you don't have really a leg to stand on because you don't have the authorship in the individual articles, but your authors can still, enforce their copyrights in their content. But the selection, the order, any introduction, any comment on why you selected things can give rise to what we call a compilation right. And there's authorship in there for that.
Great. That's very helpful. If a government agency publishes copyrighted material on its website and a company republishes that information, what is their exposure or risk?
That's a great question. It's really dependent. There's some often, the government, when they publish things, indicates that they're releasing it to the public domain. So you really have to look at the publishing body and what their rules and regs are regarding that. But most governing bodies often say that they're distributing it for public use and there's still a copyright in it, but they're giving it a right to others to republish. So, but it's different state to state, federal government. You have to, federal divisions within the federal government branches, the EPA may publish things, the FDA may, the U.S. Naval Academy publishes things, and they all treat it actually a little differently. So you have to look at the source and go from there.
It's not as easy. It's on a government website. I can use this.
Yeah.
A little deeper into finding the source and where it originally came from. I know that's a challenge sometimes.
Yes.
Kind of similar, but not. If you've obtained an image that had a Creative Commons license attached to it when you obtained it, and the license has since been deleted, and we have a specific member that had a lawyer contacting them claiming the image was copyrighted and used without permission, how do you handle that? What's the best way to prevent getting caught in that type of scam?
Yeah, that's problematic, and you'd have a pretty good defense in those type of circumstances. I think the best thing you can do is when you take something that's subject to a creative content, license, which is pretty common, you just make sure when you take it, you print out the license that came with it at that time. So you have that record. Maybe you go in the Wayback Machine, but those terms, you can't replace those terms. So if that license was, for instance, in a copyright thing, if they want to give something to the public and you don't want to be in perpetuity, there's a trick you can do. You can say for the full term of the copyright, because that's not forever. And, if it's a living person, it's, 70 years plus their life. So it's still a pretty long time. So that license for which you originally took it would still govern. And if there's any, limitations in that Creative Commons license that sort of gives a revocation right, you would have to honor that too. But it really, I encourage, a lot of people have that question. A lot of people run into that sort of scam and, a sort of bait and switch type of situation. It's very easy to respond to someone like that. But to make it really easy, when you're pulling content under those licenses, just print the license, keep a little file, even if it's digitally, and, you'll have that to always point to.
Yeah, great point. Having good documentation is always key. Well, we're out of time for today, so I'm going to go ahead and wrap us up. I think we could probably continue this for quite a while with specific questions and challenges. Again, I'll mention Rob is happy to chat with anyone that has specific questions and issues. You can contact him through the Pally and Gibson website. Also encourage members to continue our discussion on the Guild group. We've got lots of resources we can share, sample agreements. Again, not legal advice from me or other members, but happy to share what we've learned and takeaways and those sort of things. But really want to thank you so much, Rob. This was jam-packed of information, and Tom for sharing those myths with us and helping getting them busted. Really enjoyed the discussion today. We hope everybody did as well. Be sure to check out renewed.net for additional upcoming events and other resources. And thank you guys all for being here today.
Thank you, Stephanie.
Thank you. My pleasure.
Thanks, Rob.
Yeah. Thank you, Tom.
Good to work with you.
Thank you.
You too. Take care, everyone.